Thank you. At the moment, we haven't been able to find the bundle anywhere on the court records, but doesn't mean it isn't somewhere. So we still do need copies of the other documents that you're going to be referring to.
Well, my lord, arrangements are in hand at the moment in chambers to print 3 paper copies.
Good.
I'm sorry.
Not of the whole lot.
Well, the view we took was we should prepare the whole lot.
Okay.
My lord can then take a view as to...
Easier to do that than to spend time reading it out, you thought, probably.
My lord, exactly. And if anything should not be permitted, then it won't be.
Okay, okay.
Can it be sent electronically as well?
Yes, my lord, I'm instructed that it was sent electronically at 8:55.
The thing to do is to send it to one of our clerks.
Send it to my clerk, and then it can be distributed.
Well, my lord, I'll send that email now.
Yes. Do you want a paper or not want a paper?
I'm happy with electronic, but if you...
They're doing 2,
it sounds like it's already underway.
Okay. So can you send the electronic straight away? Or...
Yes, well, I'm not sure I've got a copy of it, my lord, but I know that Miss Carvalho Gomez will have.
Okay.
And as soon as she picks up my email in chambers, she'll
thank you. Right, Mr. Toomey.
Well, we will send that copy now.
Oh, you got it
Learn
electronically?
Junior has it, yes, he can.
Good, okay, thank you.
I'm very sorry to have inconvenienced the court in this way.
Don't worry at all.
I hope my lords then have the final schedule of findings from the local authority. It was simply to alert the court to, firstly, perpetrators at A66, paragraph 5.
This was the document produced at the start of the hearing, is it?
It's dated the 19th of November.
Or the end, or some point between.
At the end, thank you.
Right.
At the end.
So it is the final.
It is very final, yes. And so one sees that the perpetrator of the injuries, which are pleaded above, is said to be either the mother or the father, save in 2 particulars. And those particulars are at A63, under paragraph 2.1, which relates to the 28th of September, and the pleading refers to the 8 a.m., the father having been with the child overnight from the 27th. The local authorities case was that A and AA, that is a bruise and a cut to the child's face, were caused by the father.
And that's said where?
A63,
yes.
paragraph 2,
Yeah.
2.1 gives the date.
Yes.
Underlined below that, the examination time of 8 a.m.
Yes.
A and AA. And those are...
Where does it say?
They're expressly set out back at paragraph 5.
As inflicted by the father?
Yes. They're the 2 paragraphs to which paragraph 5 refers.
Yes.
So
thank you.
The task for the learned judge was, in fact, to determine, on the one hand, were these bruises that had been inflicted by either or both parents, the father only in relation to those 2, but either or both parents after the 28th or 27th in hospital, notwithstanding the fact that there would be some observation, as part of presumably some attempt to establish a case of propensity to bruise, or, on the parent's case, was this in fact true, spontaneous bruising arising in hospital for which there was no apparent cause. So on those 2 points, the local authorities' point and the parents' response, there was no real dispute at one level as to whether these were bruises. And indeed, what's curious about this is that learned judge does not make any particular findings. We'll come on to look at the findings, save for perhaps a coy finding in relation to the lip. It certainly doesn't descend to any of the detail relating to the injuries following the 27th, the night of the 27th. And one, if I can then just simply, as it were, hurry to the concluding point, which is where was the medical evidence as of the 28th of September and the 30th of September? Well, we have that in the main supplementary bundle by way of the forgive me, I'll just find it. The report of the consultant paediatrician, Dr.
Rose.
Petroval,
Oh, right.
the treating
Clinician.
physician, yes.
Page that
And that's
one?
page 29 in the supplementary bundle. There should be a report headed Statement for HM Coroner, but it's a useful
Yes.
summary at the bottom
Yes.
and over the page of what the doctor found on the 28th and on the 30th, and we can look at the body maps. But curiously, this doctor was the doctor who stood out as being praised by the judge as the proper keeper of records. This was the doctor who prepared body maps, signed and dated the body maps, I think, and timed them, and is very clear in her body maps and in her report. So this called for, this report and those allegations on the back of those findings by the treating consultant paediatrician called for an in-depth analysis by the there judge. And so, as it were, having rushed, as it were, to the end, can we go back to the judgment? And the judgment appears in the core bundle at 73, and ask my lords to turn to page 112, which is where one sees the assessment of bruising.
Could you show us first where she deals with the treating doctors, what you just showed us?
Yes, so
Is it 128 or is it 122? Paragraph 3. In other words, she sets out, this is her analysis of the evidence.
that's right, yes.
So 122, she sets out her summary of what you've just taken us to,
Yes,
then goes through evidence from others, and then comes back to the doctor on the 30th. So she sets out the evidence.
yes, she does. And then, in fact, while my lord has that part of the judgment, then goes on to say, to decry the poor practice at 137. And at 138, explains the difficulty she had with making a cogent picture from the hospital's evidence,
Yeah.
relying upon poor record keeping, which does not apply to Dr. Petroval. At 144, at the bottom of the page, in the paragraph, again repeats her concern about the...
The same passage is repeated verbatim.
It's repeated there, and I think it's repeated again later in the judgment. So it troubled the judge, clearly,
Yes.
that she did not have the picture she would have expected to have had. But of course, the judge has to do his or her best on the evidence available. And in our submission, the judge didn't descend into the details in the way she should have done. Because when one then comes through to, I suppose, page 111, at 165, she identifies there are two issues, fractures and bruises. She deals with fractures and birth at 165. She deals with fractures and genetic predisposition at 166. And then she starts to talk about bruising. Again, and this is where she repeats it again, that it's been difficult to analyse because of the poor record keeping. And significantly, does not refer there to Dr. Ketreval, but does refer to Donna Tustain, who was a vaccination nurse, Dr. Gill, the GP, and then says the other treating doctors, which can only mean the doctors from the 21st, the arrival in hospital, all accept that he presented with bruising. And both parents agree this was severe on the 18th. So that was the Friday before the Monday he went to the hospital. But then some of it may be eczema or marks. And then she deals with Father's Counsel's reference to foster care and concludes, the last two sentences are significant, there's a high stroke unusual level of bruising, and she's referring there to foster care. He appears to bruise easily. The evidence from foster care suggests this child bruises and or marks for some unexplained reason. Now, in due course, I'll say that's relevant to the issue of the genetic variant, but for the moment, that's her finding, or that's leading up to her finding in relation to bruising. Just slightly watered down at 164, although he may...
164.
Yes, 169, sorry. Although he may bruise more easily than the average child, the observed and recorded bruising is more severe in the care of the parents than during the period of foster care, suggestive of some level of heavy handling, whatever that means.
So is your complaint that she left out of this analysis the bruising in hospital?
Yes,
Completely?
yes. And
Yes, but you're going on to the next bit of the judgment.
yes, and so she finds the fractures proven. Then bruising 172. She repeats the point about the comparison, parents' care and foster care, and she does there say bruising was identified by all the treating doctors. So that must be the hospital doctor. So to an extent, she's finding there was some bruising apparent in hospital. Then goes on to say she finds that he may bruise more easily than other children. So there's a degree of repetition, reflection of what appears on the previous page.
Doesn't 174 deal with your point?
Well, I'm not... 174, I do not find the injuries in the hospital on the 28th.
Go on.
So that...
But then...
And then refers to the lip, says it could be swollen.
And then...
And then it
But
does
suggest that Newmark do arise, which is
which
why I also find that L may bruise more easily.
yes. Now that throwaway comment leads to her saying that it's probable bruising may be caused by heavy handling. Some allowance has to be made for a tendency to bruise. So one's getting into a position where she's saying there is a tendency to bruise, but an unspecified tendency.
Well, she hasn't dealt with your point, at least I think for my part, I can't see at the moment. She hasn't dealt with your point in terms,
No.
in the way that you say that she should have done.
Yes.
But it does look from 174 that has taken the evidence of bruising into account in some way, in hospital, in some way, as underlining her finding based on the foster care.
Yes. Yes, I think
So-
I have to accept that there's an indication to that
Well,
effect.
what she's addressed, she had been asked to make findings in respect of, to take her word, the injuries in hospital on the 28th of September.
Yes.
She'd been asked in this final schedule to make findings. Essentially, she's saying she doesn't think the evidence is good enough to enable her to make the findings which she has been asked to make.
Well, there are a number of findings she's asked to make. The very fact that the starting point is whether or not these are bruises.
Quite. But she says...
And she says, I do not find the injuries. Now, bruises are injuries, or evidence of injury. And what one sees in the consultant paediatrician's record is a significant list of apparent bruises. And so this is not like in foster care where there were infrequent but questionable incidents leading to bruises.
The list you refer to is the list in Dr. Catraval's letter that you just taken.
Yes, exactly. And the real problem is, or the problem is that she's asked to clarify by the local authority So
Yeah.
we have that following on from the judgment. In particular, 119, she's asked to determine the extent of the bruising found to have been caused by heavy handling. And the italicized is the request, and the answer is the court cannot define this any further. So the local authority is saying, we've pleaded arrival at hospital on the 21st. We've set out in our pleading what we say are the worrisome bruises. And her reply to that is she can't make a determination. So that this judgment does not decide what this child presented at hospital with. Nowhere in the judgment do we have a list of the judge's findings, other than that there was some bruising. Nowhere in the judgment, and that's despite a request, is there anything by way of a precise finding about the bruising in parental care. Now, she's described it as being, before the GP, severe on that occasion. But that surely requires a descent into some detail when one looks at Dr. Ketreval's evidence.
Well, wait a minute. You're saying not for... In paragraph 172, she found the child had sustained bruising whilst in the care of his parents in the September period. What she was asked is, can you be more specific about the extent of the bruising?
Yeah.
And she said, no.
Yeah.
All I can find is what, essentially, I think what he set out in 172.
Yeah.
So she did find that the child had sustained bruising whilst in the care of the parents, including on the back, and more than at any time in foster care.
So she finds, yes.
So she is finding bruising.
Yes.
So we need not find what presented to hospital with. There is a finding sustained bruising.
On arrival.
Prior
Prior to hospital.
to the hospital.
She doesn't find what...
What I thought you were criticising was the manner in which she addressed the evidence as to the marks on the child, which appeared over the course of the night of the 27th.
Yes.
So have I understood that correctly?
And indeed following. So the...
So what you're criticising is the judge's, firstly, paragraph 174.
Yes.
And what are you saying the judge should have done?
What the judge should have done, firstly, is determine what bruising the child had could be established on arrival at hospital. The judge should have then gone through each of these days, which are marked with body maps and records, and decided if she accepted that on a particular day there was a particular mark and what she made of that mark. And she should have done that.
What, in straight to every mark on the child?
Every mark. Well, I do say that. I do say every suspicious mark, because one bruise on a non-ambulant child will give rise to a suspicion of child abuse. And in this case, the local authority's care plan for this child, based on abuse, of which bruising is part, may well be adoption. And so one mark on the skin that is a bruise is suspicious of inflicted injury. And so, yes, where the judge is presented with a number of marks on the child, she certainly has to engage with marks that are new. She certainly has to engage with an absence of marks on the 26th and a plethora of marks and bruises on the...
Sorry, so can I just understand your case correctly? Are you saying that 172 isn't sufficient?
Yes.
That there needed to be however many paragraphs required to go through all the evidence up to that date and say, this is a bruise inflicted, this is not a bruise inflicted. Is that what you're saying?
All the relevant evidence. So she might have dealt with it quite easily up to the 27th, because we probably have a picture from the arrival in hospital to the 27th of fading marks. So she could deal with in a.
I mean, she does deal with it, doesn't she? In this sense, she says the evidence is isn't good enough.
Isn't your point about, seems to me some force in it is that she's ignored, she's not made any findings in relation to the one part of evidence which your client was not involved in.
Yeah, well, that's
And so therefore,
absolutely on perpetrator.
and
Yeah.
so where she's taken out of consideration what may be the most exculpatory evidence for your client.
Yes.
Yeah.
And then it's followed on by a more general point about propensity to bruise, because there are new bruises on the 28th, which, if they're not caused by the father, demonstrate a propensity.
Okay.
And
So it's relevant on one hand because it might treated properly. It might have been sufficient to lead to to conclude that there wasn't sufficient evidence for a finding of non-accidental.
Yes, because she has found there's a propensity to bruise.
Yes.
And so what she's sought to do is, in a very broad brush approach, and that's what I criticise her for, say, well, look, there wasn't that much in foster care. There was quite a bit in unspecified, in parental care, and I'm not going to accept, because of record keeping, there was anything in hospital of relevance, except some tendency to bruise more easily. If you're going to do the broad brush bruise more easily, do you not, if that's acceptable, I say that's not acceptable. I say you have to look at a bruise and assess whether or not it's inflicted.
Well, you need to share the expert evidence on these issues. Because what you've done at the moment is shown us a record kept by the treating clinician. But what did the experts instructing the case, what was their evidence to set out in the judgment on?
Their evidence is that what is recorded in the hospital is demonstrably bruising and demonstrably suspicious. And I think Dr. Rose was asked in his evidence about this, and I think said, well, I think in relation to foster care in particular, was asked about the appearance of bruising and pointed out, well, one of the parents was there, even though they were supervised. So his position, the single joint expert to the court was advising that we have bruising where it is recorded, and therefore it's...
Yes, but also gave evidence about standing back and looking at the whole history of bruising and drawing conclusions from the presence or absence of
Yes, I mean...
patterns of bruising or frequency of bruising.
Yes.
And drew distinctions between what had happened in foster care and what had happened in the parents' care.
Yes.
So that's part of the evidential picture that the judge has and has to take into account.
Yes. Well, interesting, the judge didn't entirely accept that expert opinion, because Dr. Rose's opinion was, well, if this is a propensity to bruise case, then you'd see bruises all over. And she didn't accept that.
For my part, it would be helpful if you could just give us the references to where Dr. Rose says that,
Yes.
and where you say the judge rejected that.
But the reason I'm asking these questions, one of the criticisms I thought that was being made of the judge's later grounds was compartmentalization. In other words, not. And I think there's a risk that this submission is also compartmentalizing and not. Okay, I understand why you're making submissions about it, but then you've also got to bring in the bigger picture, the rest of the evidence, to see where it fits within it. Anyway, sorry, you were about to find an answer to my
can
lord's
I
question.
try and find the reference?
Yes.
And give it to my lords in due course. The primary point is that if the judge is to make a finding, a general finding, that a child bruises more easily, but notwithstanding that, has suffered abusive inflicted bruises, then the assessment of the extent to which the child bruises more easily must involve a careful assessment of those bruises sustained in hospital. if the bruises set out by Dr. Ketchever in her report are sustained in hospital, as many of them or most of them appear to be, and if the local authority asks the court but failed to establish infliction by the parents.
I'm sorry, say that again, you dropped your voice.
Sorry, the local authority asked the court but failed to establish that they're inflicted, then they are spontaneous or unexplained bruises. So in a case where the judge has been asked to consider whether parents have abusively bruised their children, it's simply, in our submission, not good enough to say, well, there is a problem with this child, but it looks like it was worse in parental care than in foster care, and not to deal with the period in hospital.
Because not to deal with it
It's not the full
puts it in the balance against the parents.
Exactly, and it's not the full picture. The full picture is of a child who turns up with bruising that's unexplained. On the 28th, the child has bruising, new bruising, which is unexplained. So how can a judge, without descending into the particulars, say that the bruising in the parental care was abusive without some assessment of the extent of the bruising in the hospital?
But hasn't she done that in the line, in the phrase in 174? Isn't she taking the bruising in hospital into account? Come back to the perpetrator point in a minute. But isn't she taking it into account there?
She refers to the lip and says it suggests new marks do arise. So she's referring to one injury.
Which is why I also find
Yes.
that Lucas may bruise more easily.
Yes, but that doesn't do justice to the body map of the 28th, which we can see in the supplementary bundle. This is I'm only going to deal with Dr. Ketchever's maps, which is page 23 for the 28th.
I'm sorry, 23 of what?
Of the supplementary bundle, the first supplementary.
Yeah. This is signed.
Signed, timed, dated.
Yeah.
Page 27, 2 days later, signed, timed and dated. The judge, we suggest, appears to have effectively thrown her hands up in horror at the record keeping, but in doing so has simply not addressed herself to the significant findings of the consultant paediatrician. I mean, it is a peculiar of note, is it not, that the period in foster care is not marked by an overseeing treating doctor of any description. The period in parental care is marked by a vaccination nurse on one day and a GP a few days later. Yeah. But the period that the child is under scrutiny by not a GP, not a nurse, but consultant paediatricians in hospital is the period she doesn't deal with.
So looking at the two, are you saying that she can, that in sweeping or putting to one side the medical evidence in the way that she did, she erred because on her own analysis she ought to have accepted Dr. Ketchever.
Yes. And
by
then,
comparing and contrasting these two body maps.
yes.
And in particular, the difference, isn't there a difference between the two?
The most significant difference is between those two maps and the page 14, which is the map of the 26th, which in terms expressly says no bruises on the body.
Okay. It was 14, one of the...
This is just dated, unsigned. On the right-hand side, just by the first hole punch, no bruises to the body. Next page, no bruises to the body on the 27th. And then one gets to the 28th. on page 21, where we now have bruising and scratch marks over 22, the same time, 8 a.m., the mark bruise and scratch the face. And the local authority is saying, well, this is the father.
Okay, so come back to perpetrator in a minute, it's an important point, but really you're saying the judge attached too much weight to the poor quality of the record keeping.
Yes, she lost sight of the fact she had a consultant paediatrician reporting bruising, which is indicative of paediatrician reporting bruising, which had not previously been apparent on the 28th and on the 30th.
Okay, so in particular you say that the fact that she had two body maps, and I don't want to put you into a corner you don't want to be in, so don't let me, but she had two body maps, 26th and 27th, unsigned and unattributed, but nonetheless each saying no bruises on the body.
Yes.
And then on the 28th and 30th, she has high quality body maps, each identifying bruises on the body.
Yes. And in any event, identifying new bruising. Whether one goes to the 20, if one ignores the 26th and the 27th.
So 14, 15.
And I suggest that it's a judge determining a serious issue of inflicted bruising on a little baby cannot ignore the requirement to descend into the details of these bruises on the 28th and the 30th.
Can I ask you about the entry on page 20 of the supplement, written in retrospect, 1645 on the 28th?
At 1645?
Yes.
Yes.
And this records the discussion with the father.
Yes.
The first thing I just wanted to ask you about is that this baby at this stage is what, 9 weeks old, 10 weeks old?
Yes, I think that's right.
And this suggests that the baby hadn't been fed since 8 o'clock the night before.
Yes.
Seems remarkable to me.
Yes.
Maybe fed every 3 hours at that age.
Yes.
Isn't he?
Yes. Well, he's probably a little bit older, but yes.
3 months.
3 months, 12 weeks, yes.
I thought he was born in June.
Yes.
Yes, sorry. Yes.
Yeah, 24th.
Sorry, it's June. Yes. But then, and the father's explanation is that he'd heard Lucas crying and he thought he must be hungry. Well, it's not surprising. Since he had no feed since 8 o'clock last night. And then went to him, noticed the mark on his lip, which it said was bleeding. He showed me the bib, which had evidence of bleeding. Well, a bib will be put on when the baby's fed,
Presumably.
So, I thought this suggests that that injury may have occurred when the baby was being fed.
Yes.
Makes sense.
It does, yes. But those are the sorts of matters that it's incumbent upon a trial judge to examine.
Can we go back to the perpetrator point, which
Yes.
I've all raised? By extracting from her consideration, as it were, removing anything about the bruising in hospital, she took out 2 marks, which, on the local authority's case, were inflicted by the father, and did not bring them into consideration when reaching a conclusion about perpetrator.
Precisely, my lord. And we would say that that sort of evidence is far more, it's a different category, far greater cogency when looking at the identity of a perpetrator than that which the judge did look at when she came to identify
which we'll come on to later.
Yes. But that is absolutely front and central of the issue in a case such as this. But my primary point really relates to the substance of the bruising and the requirement, I say, upon a judge in a case such as this to determine where there is bruising, which is a suspicion in a non-ambulant child of abuse, how it has arisen in hospital. The local authority said one thing, the parent said something else.
There was quite a lot of evidence, which she recites
Yes.
in about 60 or 70 paragraphs.
Yes. She goes
70
through
onwards.
Exactly, my lord. She takes the chronology very nicely through from the early points up to the health visit, the nurse, the GP, hospital. But that's one thing. She has to assess the evidence. And I mean, when one's asking, well, what, as the local authority did, well, what was it the parents did wrong? Then effectively, that's their request, isn't it? Is it not? At paragraph 6. What did they do wrong? The mother, rather. What did she do wrong? She inflicted bruising, but to what extent? I mean, that finding that is made, it could be 2 or 3 bruises. It could be half a dozen. It could be a dozen. It could be 2 dozen. And that, I suggest, illustrates the difficulty with the broad brush approach, but particularly the broad brush approach that omits an analysis of the hospital bruising. So the judge should have found what could be proved about what the child turned up with on the 21st in hospital. Should have found what, if any, new marks were caused, what, if any, new bruises were caused. I say marks because if a child easily marks, that is clearly relevant, I suggest, to the judge's determination of what happened in the parents' care. I mean, she does make an allowance for eczema and some marking occurring naturally. So if she finds that there is significant marking, not bruising in hospital, that's also relevant. So she should have found if there was new marking, if there was new bruising, and she should have made a decision about how the new marking, but more importantly, the new bruising arose. And she had the local authority saying it was malign, and the parents saying it was benign.
Was her finding that she couldn't make a finding because of the deficiency of the evidence one which no judge could reasonably find?
I think the difficulty with that finding is that, from what I can see, both parties, both protagonists, parents on the one hand, local authority on the same, we're making the point, these are bruises, these are injuries. So for a judge isn't bound by the parties, of course, but the case has been advanced on a basis, defended on that a certain basis. And if the judge is going to say, well, I know the local authority say these are bruises, and the parents say these are bruises, but they've each got their own take on these bruises, for her to then say, but I don't find they're bruises, there has to be pretty cogent evidence, I suggest, for her to do that, because the issues are being narrowed and the witnesses examined on the basis of the issues between the parties. So she could, I think, say, with, for example, the body maps on the 21st, that, as she did, there were a lot of difficulties, and she made certain criticisms. I still say that she should have identified what the local authority could prove as being on the baby's body on the 21st when he got to hospital. I mean, as a bare minimum, she should have said, I have some concerns, and notwithstanding those concerns, given what the GP says, and given what these body maps illustrate, I find as a minimum this child turned up with the following bruises or marks, which she doesn't do, hence the local authority's request.
Carlos, do you also say this? When the judge says that Lucas had a propensity to bruising, what does that actually mean? Presumably it means that handling which would not have caused a bruise on an average child might cause a bruise on Lucas.
Yes.
So if that handling which wouldn't normally cause a bruise has caused the bruises. In what sense can you say it's heavy handling? It seems to me it's very difficult to categorise what sort of handling will have caused bruising on a child that's got a propensity to bruise.
Yes, I mean, if I can use probably an unhelpful numerical scale, let us say that acceptable handling is 1 to 7, unacceptable is 8, 9, and 10. But this child bruises on 5, 6, and 7, 8, 9, and 10.
Well, there was evidence about this, wasn't there? Expert evidence.
About the...
Well, there was expert opinion.
Yes,
That notwithstanding the propensity to bruise, and the expert opinion of Dr. Rose, these injuries, this bruising was inflicted.
Yes, but she didn't accept that evidence because she finds that there is a propensity to bruise. I have to find the reference for my lord. But that was against the burden of Dr. Rose's evidence. Yes, so if I suppose in concluding in relation to bruises, go back to the judgment and 173. She finds the child may bruise more easily. I'm not sure what that means. And then she says, I do not find the injuries in hospital on the 28th. I'm not sure what that means. But if she says that the bruising noted by the doctor on the 28th and the 30th was not bruising, then she needed to say so. If she finds it was present, but without a clear without a perpetrator, then she needs to say it was spontaneous. And then she needs to weigh the level of the bruising. She only considers the lip. So, really for those reasons, and in relation to ground one, primarily I'm not arguing the perpetrator point,
No.
but for those reasons, in particular, the failure to get to grips with the hospital evidence, it's not a full picture. And there has to be a full picture before findings of this abusive nature are made. So, unless I can go further with that, I was going to move on to the issue of the expert evidence, but particularly, I need to come back to Dr. Rose's reference.
Yeah.
But if I can try now to deal with the genetic issue.
Well, are you going to make any submissions about the fractures?
Yes,
As
as part of the genetic.
As part of the genetic.
Yes,
Okay.
because what's interesting about the finding, whatever the finding is about propensity to bruise that the judge makes, she does appear to make a finding of some propensity to bruise. So, as it were, coming to the issue of genetics and the known unknown that we have in this case, that is highly relevant to considering the issues raised by Dr. Ellis. Now, ground 2 refers to the judge's error at paragraph 7 of the judgment, at 75 in the law bundle. Which is that the
Not with a propensity to
not the
bruise.
propensity, yes, exactly. And I mean, there are various references in Dr. Ellis's reports, but for example, at page 230 in this bundle, paragraph 110, he expressly addresses bone fractures. From paragraph 87 at 222, over a number of paragraphs, he raises the difficulties, or the association, but the difficulty in drilling down into any more detail than that as between LDS.
I'm sorry, I missed your page reference.
Sorry,
there.
222.
Sorry, my mistake.
Paragraph 87 and following, he looks at research in relation to fragility of the fractures.
Where does he deal with young children?
Well, he...
Paragraph 88.
Yes, I mean, and following, because he... yes, at 91, for example, he talks about an absence of evidence relating to infant fractures in the last sentence.
Sorry. There was no mention of fractures in infancy.
In that one. So it's a difficult issue, but perhaps the obvious point is what he then says at 98, at 226. My lords, that this is copied into the judgment, albeit with a significant omission, which is, I think it's paragraph 60 of the judgment, but it's in effect, paragraph 98 is repeated in the judgment. And these are the three options that the expert was concerned with. And that is that the variant of unknown significance could give rise to three conditions. The first, no clinical significance. The word no is left out of the judge's judgment of paragraph 60, but I think she means to copy that paragraph in its entirety. It might be causative of LDS. And then he goes on expressly to say, or it may have some partial effect, so an incomplete form of LDS, but there might be some increased genetic propensity to bone fractures or to bruising. So clearly he has that in mind. And for the judge to say at the outset...
Well, he had that in mind then, but his evidence progressed. That was before the analysis of the parents.
That's right.
And his more detailed analysis of the history.
But the point is, the general point, before we get to the particular of the child, the general point the judge makes is incorrect. There is no propensity to bone fracture. She couldn't say that. Dr. Ellis wouldn't say that. In fact, Dr. Ellis drew attention to a number of associations with bone fractures. And then at paragraph 8 of the judgment at 75, she refers to the parents raising the variant as being responsible for the bruising and the fractures. So having said at 7, it can't be responsible for the fractures. She sets out that as being the parents' case.
And no questions were asked about that for clarification as to what she meant.
No, I think that's right.
Well, what do you say about her summary of the conclusion of Dr. Ellis's report at paragraph 61? Where he...
So what we say about that is that that was Dr. Ellis's clear opinion, and it was an opinion she was entitled to accept. And so we do not say that accepting his opinion, she fell into error. what we say is she was entitled to accept his opinion, but it's then the analysis of the issue and how she factors his opinion into that analysis that we criticise. And firstly, we say she didn't consider the opinion with all the other evidence, all the other relevant evidence. And secondly, she didn't descend into the detail which the opinion required when considering the scope for an innocent explanation of this child's symptoms. So the fact that he was not able to make a diagnosis is clearly relevant, but the absence of expert evidence explaining fractures due to fragility does not mean that this child did not have some form of fragility.
Sorry.
Or there's some...
Yes. Sorry, are you moved? You said your first submission was didn't consider this opinion with all the other relevant evidence.
Yes.
Have you completed that submission?
Well, you were
Because-
summarising your
Well, that was a
submissions.
summary.
The second
Okay,
one was not descend to detail. to
And
the
now you're
extent-
enlarging on those
To the
submissions.
extent
Yes.
needed.
Okay.
Yes.
Okay.
Thank you.
It would help me if we could just look at precisely where in Dr. Ellis's report you accepted that's what he said,
Yes.
and just for my note, exactly where does he say it in those terms?
I think it's his third report.
Well, she says his original report.
Yes. Well, I mean, that's clearly correct in that he hadn't identified a condition that would predispose, but he obviously had identified a condition that might, which is why the testing was undertaken.
Right.
So,
I mean,
so it's
it would help me.
the second report.
Well, the first report, am I in the right place here? The first report concludes at 232.
Yes. So he's not identified anything, but further testing is required.
But I can't rule out the possibility.
Yeah.
Yeah.
And
So that's where she says that.
yes, and that
She says that.
the testing, the reason for the testing is at 227, paragraph 100, where he anticipates the potential findings on testing, the three potential outcomes. Firstly, that the variant's not found in either parent, and he felt that that would provide a real possibility of some mild form of LDS2. If found in the father, at that point he was quite clear there would be no bearing on fractures or bruising. And then he considers the position in respect of the mother. It's obviously category 2 that matters, because the father then tests positive for the same. And then he deals with that at 265. At the top of the page, also being found in his father. And in this way, given that father has no personal or family history of recurrent bone fractures with reduced trauma of significant bruising, I'd regard the gene variant as coincidental. He goes on to say there are, and then he says extremely rare cases, and here he's talking about non-penetrance. He refines that in his oral evidence to the Guardian and says it's rare, not extremely rare. I can take you to the passage. The extremely rare conditions where gene mutations may not show clinical features in an individual but can be passed on and be associated with clinical features. This is non-penetrance. So the issue for the judge with this evidence is that she then, I suggest, has to consider the father's fractures or absence of fractures and what Dr. Ellis says in paragraph 15. So, for instance, the father had certain fractures which are recorded from the age of 6, and they're addressed in some detail. But the child with which the court's concerned had silent fractures, metaphyseal fractures, and rib fractures. So it is possible, and the judge should have considered, it is possible that the father too had silent fractures that were not picked up in infancy.
Was
the
the doctor asked about that? Dr. Ellis?
Don't think.
I picked up no hint of that as a possible suggestion in the papers.
Well, it's rather
missed something.
The point is, I suggest, that the opinion is based upon 2 points. One is the absence of fractures in the father, presumably in infancy, being most relevant here. And one can't necessarily assume that the father had no fractures. But secondly, there is the possibility, albeit it is rare, for a father to have no clinical symptoms, but to pass that on to the child.
Yes, but the first point, he was saying that the evidence completely overlooks, the medical evidence overlooks possibility, which is that the father had unknown fractures that nobody was aware of. Which, and all I was asking is, were the doctors asked about this? Was this advanced as a case in any way, shape or form?
I don't think it was. May I
Right.
just check?
So it's a new point. Is it?
No, but that wasn't pursued in any detail or at all. But it's a submission that I suggest that a judge needs to consider the underlying reason for an opinion.
Well, your point, I think is that she's cited that judge at paragraph 62, doesn't she? That by itself is unobjectionable for the doctor to say that.
Yes.
It's unobjectionable for the doctor to say, with his expertise, that it will be highly unusual and well outside of bound probability for a variant responsible, as he goes on to say, for it to have the cluster in L, but not in the transmitting parent. But this is really your compartmentalized point. It's not, that doesn't rule it out.
No.
When the judge comes back in the final analysis to consider all the evidence.
Exactly so.
At which point she has to take into account this possibility, however improbable.
Yes.
That's what Mr. Justice Charles, etc.,
Yes.
told us all those years ago.
Yes.
I'm sorry, Mr. Toomey. Just would a judge not be criticised for speculation if the judge in the judgment raised an issue which nobody had raised during the course of the hearing? No expert, no counsel, no party. Went off on a frolic, one might say, of their own and started speculating that this might be an explanation, not based on any evidence given by any expert.
Yes, I mean,
It would be chaotic if parties on appeal could put forward speculative ideas that had never been raised before, not even in their oral submissions in support of the appeal.
Well, that must be right. So let me, as it were, not press that point and withdraw it. And let me adhere only then to the other point I was making.
We couldn't function with speculation being undertaken by judges. I'm not talking in those circumstances.
No,
Sorry,
I agree. I mean, I agree with that. I mean, if I wasn't.
The judge's addresses unknown cause.
Yes.
Right. Yes.
So the non-penetrance point, just for the reference, is line 9 at 178 in the supplementary bundle, where he reduces that, as it were, to rare rather than extreme.
Have we got your closing submissions yet?
Yes, we have those.
Are they
Focused?
what we've got, or are they what's coming in a minute?
Oh, they're coming. Yes.
Okay, all right.
Sorry, you said you were just telling us. Is this the transcript of the oral evidence?
Yes, it is. So
Let's look at that.
what, please, 178. This is examination in chief by the Guardian, which at line 9, he says, having been asked about it being extremely rare, this is non-penetrance, he says that LDS is a group of conditions in itself rare. It may be that family members are carrying the gene who have not been investigated, but to our knowledge, the numbers of people who are non-penetrant is small in this condition. I think I may have said extremely rare. I think I may have overemphasized the point. I would say it's rare. I wouldn't necessarily say it's extremely rare.
Yes.
So, and then the lower down, whilst we're here, if I may, paragraph, line 25, there is no agreed consensus guidelines for the diagnosis of LDS. Then 187, line 6, the sequence change found in the child has not been reported before. We don't know how many people have it. And then line 17, it has to be an exceptionally rare condition, because he says one can say if it does occur, it's exceptionally rare, because there are now the sequences of tens of thousands of people. And then asked about the degree of penetrance at 26, because it's so rare, is it fair to say there's little, as it were, learning on the degree of penetrance? There is an area of unknown. I would call it significant unknown. And then on to 190, if Mills would. Question at line 17. So does it follow that you could then have this variant of unknown significant with some of the expressions of LDS, but without others? You'd regard that as an association? Yes, it would be a weaker association, but yes, it might be part of what we now call multifactorial disease, where it may not be called a mutation, but it may be caused by a predisposing gene sequence. And then 223, so some way on. At line 10, on behalf of the mother, consider this possibility, doctor, that between the ages of 6 and 14, Leon, the father, suffered bone fractures and doing quite ordinary things that wouldn't otherwise have resulted in fractures, but that he's been all right since. And that was an expression, a passing expression of this genetic, of the US. Is that a possibility? It is a possibility. And then in answer to questions on behalf of the father, at 226, line 14, question, in relation to this variant, we're really at the very start of the process, and the process that's been asked about is association of clinical features with a given variant. Answer, you put it very well, it's a process of information gathering and the passage of time that may fill in many gaps. So one then goes to the judge's analysis of the issue, and I accept that she, for instance, at paragraph 53, identifies page 86 of the core bundle, identifies that the gene variant is extremely rare, and correctly identifies that a variant of unknown significance is relevant. She correctly at paragraph 98, oh sorry, that's wrong, paragraph 60 identifies, albeit with a typo, page 88, the three options identified by the expert. And in particular, I say the third option. But then when one comes on to the analysis, in our submission, it's really to be found, page 111, where the judge looks at the fractures and deals with birth related at 165. And we say her analysis of the evidence of Dr. Ellis and its relevance to fractures is contained within 166. Firstly, she says there's no genetic predisposition in the views of Dr. Ellis. Well, that's not quite accurate, and although it's a small point, potentially has larger consequences, because what Dr. Ellis is advising is that he could identify no genetic predisposition. He certainly couldn't rule it out, couldn't say it was impossible. So it's a slightly different or incorrect reference to his opinion, but it's important. What she should have considered is that there was no predisposition that he could identify. The lack of a medical diagnosis does not mean that there's no medical cause.
Sorry, I'm not following. She says the evidence of Dr. Ellis is that he, in his view, can identify no genetic predisposition. That was his view.
He could identify none,
Yes.
exactly.
Yes.
That's not what she says, there is no genetic predisposition.
In the views of Dr.
Yes,
Ellis.
yes. Well,
So-
that's his view, was that he could identify none,
Yes.
not that there was none.
Unknown cause, your point then.
Yes.
But then she goes on, the court has considered whether there could be a medical explanation beyond the scientific certainties of the current age.
Yes.
Doesn't that cover it?
Well, in relation to that, it's rather, I will come on to the Lucas direction, but it's rather a summary reference.
Or
It could-
relaic, you think?
Yes, it could appear in any judgment of any allegation of non-accidental injury. This case called for far more. Firstly, she needed to grapple with the fact that, as the name suggests, the significance of the variant was unknown. So there was an identified unknown, not a general, it could be an unknown cause, as one might trot out in any non-accidental injury case. And the clinical effects can't be established. She should have looked at the three options, and in particular the third option, which is potentially relevant. And in doing that, she should have considered the possibility, rare as it might be, that in the light of Dr. Ellis's evidence, even though he thought it didn't meet the probability test at all, it was rare, this child might have a condition, that condition passed on to him by his father, which was not, did not give rise to clinical symptoms in the father, but did in the child.
Sorry, the court has considered whether there could be a medical explanation beyond the scientific certainties of the current age, but there is an inherent inherent probability. I think she means improbability. In those fractures all occurring in the care of the parents and the aunts, and none thereafter, despite the child becoming ambulant.
Yes.
That is something the experts pointed to.
Yes. And it's something she has obviously to consider.
Yes.
But that's part of the picture. And here it is the conclusion. This is not a judge setting out a case, as it were, against infliction as against the case in favour of infliction. This is a judge saying we can work on the basis there's no predisposition, because that's the opinion. And whilst that, I can't rule out medical uncertainties.
If you go back to paragraphs 62 and 63, the judge summarises Dr. Ellis's evidence there, including in particular 63, his evidence that there is, in his opinion, obviously, no genetic predisposition that would account for bone fractures and bruising. And going on, he regards the variant as a coincidental finding that does not need further investigation. That was his evidence. That was the evidence accepted by the judge.
Yes, and there's no criticism of that.
No criticism of the judge accepting that evidence.
No. It's what she does with that evidence, and in particular what she does with the evidence relating to the third of the three options and the issue of non-penetrance, which she does not address. And she does not address alongside, it's an issue that should have been addressed alongside all the exculpatory evidence, or the evidence that might point away from infliction of injury.
So, sorry, Dr. Ellis's evidence was that the variant was a coincidental finding.
Yes.
And
Not relevant, therefore.
Not relevant,
Yeah.
exactly. So you're saying that she should have considered its relevance, but she accepted his evidence that it wasn't relevant.
Yes, but part of that evidence was that it was not relevant, it was coincidental, because on the balance of probabilities, whilst there was an alternative explanation, that is, the child was exhibiting symptoms that the father didn't exhibit for the same inherited defect or variant, he said that was rare, and so his opinion was based upon
Well,
that.
you don't think, you say the judge should not have taken Dr. Ellis's conclusion this was coincidental as definitive.
No, exactly.
So you don't. I think you agreed with my lord a moment ago that you didn't challenge that, but you said you did challenge what she did with it.
Yes, it's not the end of the story.
Right.
So yes, that's his opinion, but within that opinion, there are various building blocks. One of which is the possibility, though rare, of the variant of unknown significance having significance in this case.
Doesn't, I mean, you say, is my word formulaic, you dismiss what she says at 166 about taking into account medical explanation upon the side uncertainties of the current age. But isn't she then taking into account that point, that Dr. Ellis's view may not be definitive?
Well, if she is, it's not clear, and on such a significant issue, she should be clear. She should explain why it is that, notwithstanding the parents' protestations to the contrary and the mother's protestation to the contrary, she is finding that the mother inflicted these injuries. So she's entitled to say, this is Dr. Ellis's opinion, but she has to deal with the rare possibility that there is an explanation arising from the child's variant of unknown significance. And she needs...
Isn't that... Why can't we proceed on the basis that she had that in mind in those words in the middle of 166?
Because what I would say is she has to weigh in the balance all the factors that point away from infliction of injury. So the issue relating to non-penetrance being one. Can I just indicate what I would suggest the judge should have addressed at this paragraph or at this point in her judgment? So it's not simply moving from the opinion to a conclusion with the usual caveat, but she should have taken account of the fact that within his opinion, Dr. Ellis required the testing to be undertaken in the first place because of the fracture caused to the clavicle when the child was born. One can see that, particularly, for example, in the core bundle at 217, paragraph 66, Dr. Ellis notes the child had a fractured clavicle at birth, which might also indicate a lower threshold for him to sustain bone fractures. So that is something that comes back into the equation when the judge is looking at all the evidence.
Sorry, it is classic, proper medical expert evidence to look at differential diagnoses. But the expert goes through that. And it is your submission that the judge has to go through the same differential diagnosis exercise, even though the expert, having done that, has reached a firm conclusion as to what that expert thinks or considers the evidence establishes.
The judge has to look at the two count of the evidence in favour of perpetration and against perpetration, all the evidence. And it is relevant that the geneticist identified this fracture as potentially being indicative of a tendency to fracture.
Yes. Then undertakes further investigation or
Yes.
after it comes to a conclusion.
Yes.
And the judge accepts that evidence.
Accepts that conclusion, accepts his view about that. But just as with non-penetrance, she then still has to go back and ask herself whether the fracture at birth might be indicative of a propensity, even though Dr. Ellis has found no evidence to identify a propensity to fracture. So the question for Dr. Ellis is there evidence to identify a propensity to fracture in the child's genetic makeup? The question for the judge is there evidence to demonstrate that the mother fractured the child's bones?
So the first point is the judge should have dealt with the clavicle fracture.
Should have considered the clavicle
That's
fracture.
the first.
Yes.
Yes, second one.
And in doing that, it is of note, and this is at the first page of the supplementary bundle, that the obstetrician, who I believe couldn't be found,
Yes.
in the handwritten note, describes how the rest of the body was delivered with ease.
Yes.
The judge should have then considered, in our submission, the finding that she made in relation to propensity to bruise, because she had found no medical explanation for propensity to bruise. She's been asked to consider whether there is a real possibility of no medical explanation for tendency to fracture. Surely that has to be weighed in the balance when the point of the testing and the point of the opinion of Dr. Ellis was to assist the court in understanding whether there was a propensity to bruise and or fracture. And that is the third option. That is a mild form of LDS that might give rise to fractures or bruising. She's found there's a tendency to bruise, and she's found there's no medical explanation. Does that not fall into the...
Where does the evidence demonstrate any link between a genetic condition that leads to a propensity to bruise and a genetic condition that leads to a propensity to fracture?
The only evidence is that in the third option that's presented by Dr. Ellis, which
Yes,
is...
that's the third option on his way to a conclusion. That's not his ultimate conclusion as to the existence of a third option.
Exactly. But when the judge comes to consider his conclusion,
Right. Okay.
as she needs to look at the possibility that he's wrong because, or that there's some non-penetrance, rare exception, she also has to consider that this may be part of a bigger picture of unknown cause.
And I have to ask again: was this put to the experts?
That if there, well,
That the absence of explanation, if there was, for the propensity to bruise, was relevant to the diagnosis of the potential reasons for the fractures.
was the absence of the propensity to bruise.
No, the absence of genetic, identifying any medical explanation other than we have an infant who appears to have, as found by the judge, a propensity to bruise.
I don't think so.
I have no idea whether that is indicative of anything other than that some people have a propensity to bruise more than others. It could be. I have no idea. So you're asking us to, you're submitting to us that this is a relevant finding to the fractures.
Well, in the broadest sense, in that she has found that this child has an unexplained medical condition, and she is being asked to find that he has an unexplained medical condition in relation to something else.
I don't think that's what I'm questioning. Propensity to bruise, is that an unexplained medical condition?
It is on the judge's finding.
Or is it just some have propensity, some infants, some people?
Well, she says it, the judge says it can't be explained.
Yes, but that's not, okay. Anyway, yes, okay, so you say propensity to bruise should have been, is the second factor. The third?
And then if she had, well, on that point, had she made the correct findings in relation to bruising, it would have been a stronger point. And then I suggest there is the sort of broader canvas evidence, which includes the mother's care for the child, in particular, how unlikely it is that a mother would inflict these injuries on her little baby, how the mother and baby relationship was observed by the first doctor who reports at, it's page 4, Dr. Abina, of the supplementary bundle. It's paragraph 9. He deals with the mother-baby relationship. That should have weighed in the balance. She should have taken account of the absence of any significant evidence arising between the parents and the messages. So the court had available to it a whole host of messages passing between the parents, out of which, unusually I would suggest for a case like this, there was no inference drawn.
No,
Adverse
whenever it's drawn against
them. It's as we know these days, everything is written down in some way, shape, or form in a text, which can come back to.
Or was there anything? Yes, of course. Was there anything more positive about the mother that was gleaned from those messages?
I don't. No, my lord, there's nothing particularly, save that the mother does take a lot of photographs and makes those available, and the provenance of those photographs was questioned and assessed by an organisation, a forensic organisation, and found to be accurate. So when the mother says, I took this photo on this particular day, it looked as though she did. So in all those circumstances, the judge should have weighed all that into the balance and really considered in some detail, really considered the possibility that this was a case of unknown cause. And simply setting out in paragraph 166 what she does is not to put the other side, is not to consider the positives. And of course, the reliance is placed upon the absence of fractures in foster care. I'm not aware the child was scanned after going into foster care. So there's some cautions obviously required in relation to that. But the fact of the matter is that none of the positives are weighed in the balance. And then the judge goes on to deal with the bruising. So we have 166, and then 167 through to 169 is bruising, and 170 is the findings on the fractures. So it comes to this, I submit, that the finding on the fractures is based upon paragraph 166 and all that's contained therein, and therefore not based upon any of those other matters that the court should have considered. This was potentially an unknown cause arising out of a known unknown, unlike most cases where there is simply an assertion of some possible unknown cause.
Thank you.
If I move
Yes.
on to the issue of the Lucas direction lies.
Before you leave issue, can I just raise one thing that I think Dr. Ellis was actually asked about silent fractures. Perhaps not quite in the same context, but they were raised with him on page 227. Line 23 and following.
Two two seven.
227 of the supplemental bundle.
Yeah.
Yes. Yes.
Yes,
So-
thank you. So in relation to the judge's treatment of lies in the Lucas direction, my starting point is to remind the court of the matters set out in the judgment that we have in the authorities bundle of Re-A, the last authority, the judgment of Lay Justice McCurr.
Sorry, which page do you want to go
So
to?
143.
143, thank you. Yes.
Where the Justice McCurr sets out the guidance from the Crown Court,
Yes.
the Crown Court compendium, the useful summary, and in particular those numbered 1, 2, and 3 in the first paragraph. That is, it must be shown to be a deliberate untruth. That's the first question. Secondly, it must relate to a significant issue. And thirdly, it was told for a reason advanced by or on behalf of a person for some other reason, which does. So in other words, it must point to guilt. guilt must be the explanation for the lie. And that over the page of 58, the court needs to consider those matters 1 through to 3, the deliberate lie, the significant issue, the basis on which it can be determined that the only explanation for the lie is guilt. So that is what
Yes, I mean,
Lucas means.
Slightly, the only explanation is a bit overstating it anyway. An explanation. Otherwise, we're going too far in the other direction. But yes,
Well, for it to be corroborative, it has to be the explanation.
well, yes, but the submission is not. It's the only explanation. It's for the judge to determine its significance and relevance.
Yes.
Yes.
Now the first potential lie, or the first treatment of lies, I suggest, comes in the judgment at 107 under the heading presence of the maternal grandmother.
Sorry, 107.
Yes, in the
Yes.
main bundle. And in particular, what is said to be the misleading chronology, which 149 concludes it was clearly meant to mislead the court. And the judge says this, that she does from time to time in the judgment. I give myself a Lucas warning. Now here, I suggest it is clear that whatever else she concludes, she does not draw she does not conclude in a way that could corroborate an allegation against any in the pool. So she says the 3 individuals came up with a story. The purpose isn't clear. In other words, she's not satisfied that it was a deliberate lie to hide guilt. It does not follow the grandmother has inflicted the injuries or seen anyone else do it. It does not assist me in relation to guilt. So it's very clear that in relation to the mother, the father and the grandmother, this issue does not assist the judge in relation to guilt. The judge then refers to the impression of lay witnesses on the next page. And she says at 155, the mother has told a great many lies, and she sets out at 155, the mother told Miss Tustain that she'd been asked if she'd been hitting the baby. And she also refers to the chronology as misleading, but she's already dealt with that. At 156, she says the mother lied about the birth process, and that is presumably about the baby not being in the breech position, which she refers to at paragraphs 35 and 47, and the fact that she told the grandmother and the police that the baby's head was turned inside by hand, which the judge said that even allowing for distress wasn't true. But those are lies at 156. She also at 156 says that she told the police that the child had bone and blood disorders causing bruising. She also says, so just pausing there, and she says, I give myself a Lucas warning in relation to her. Some of her lies as to whether the child was living there may be due to obtaining housing. Whether the father was living there may be due to obtaining housing, but there's a possibility they could have been to protect him. So we know what the Lucas direction means for the mother misleading the court about the father's presence in the home. It's not indicative of guilt. We don't know, because she doesn't say, what the Lucas warning means for the other lies at this point in the judgment. She gives a Lucas direction, as I say, in relation to the grandmother. I've addressed that. And at the same time, all three parties at 150. So the grandmother gets an express Lucas direction at paragraph 74. I'm assuming, although it doesn't say, that leads to, it must be right, that leads to no indication of guilt.
174.
Page 92, paragraph 74.
Sorry, my mistake. Thank you.
So the grandmother gets an express Lucas warning, which one assumes didn't give rise to any corroboration against her, given the outcome. 150, I've been to, all three parties get a Lucas warning. 156, the mother gets a Lucas warning about the father's living arrangements. 157, she concludes about the medical chronology and telling the father that she got an appointment with the GP when she hadn't, as indicative of wishing to cover things up. So that is therefore presumably a lie about a significant matter, but she doesn't take it any further there. The father is then addressed at 158 and 159, and 159, the Lucas warning, again, it's not particularized what that means, but one assumes that it was benign, the outcome for the father, because it's not held against him. There's a reference at 160 to the maternal uncle, another grandmother at 164, where there are, again, Lucas directions given. Then one with the mother comes on to her and the importance of lying at 179. This mother is one who has had a pattern of lying throughout. The first is something that may not be substantial, and she's dealt with that. That's her grandmother being away. The second appears to be the father's non-occupant of the family home. But what she is concerned about is what happened on the mother's account at birth, and that she had told the father she was seeking medical assistance when she was not. Now, what she doesn't do is she doesn't set out the Lucas direction there, and it does not set out the 3 steps that are required. In particular, she does not identify, as she should have done, the significance to which they relate, but more importantly, on what basis it can be determined that the only explanation for it is guilt. Now, it's been suggested that the judge only might be criticised for her approach to the Lucas direction when looking at perpetrator. But as I've demonstrated, the issue of lies and the mother's role in telling lies is highlighted throughout the judgment, and certainly before one gets to the conclusion about perpetration.
Can we just pick you up? The law's mentioned this. I know Lady Justice McKerr used the word only. I'm well aware I agree with her judgment in that case, but is that not setting it too high? Doesn't the judge have to consider, is it only if it's the only explanation for the lie is guilt that can be taken into account?
Well, taken into account, it's always taken into account, because the first thing the judge has to do is to ascertain the facts. So if someone's lied, then that's relevant to ascertaining the facts.
Well, no, a lie might be irrelevant to the determination of the relevant facts.
It might
In particular,
be, yes.
and the judge decides that in respect of some witnesses, lies were irrelevant to the determination. What a judge has to look at is not only whether or not a witness has lied, but the relevance of that lie to the issues he or she has to determine.
Yes.
Bearing in mind or taking into account that there might be explanations for it other than the lies being indicative of wishing to cover things up, as the judge found in this case.
Well, I suggest there are two issues. There is the question of whether or not these were inflicted injuries. And as part of the broad picture and the full tapestry of the evidence, if someone has told a lie deliberately, and that is to out of guilt, then clearly that is relevant to whether or not the injuries were perpetrated. When then coming on, having decided that these were perpetrated injuries, to determine which of two people, I still say that it's only relevant because in a case such as this, where the local authorities say you have two people in a pool, that's ultimately was their position, and there's no finding of failure to protect. So you've got a guilty person and you've got an innocent person. Then you are, in seeking to identify the guilty party, by relying upon the evidence, seeking to establish their guilt. So the lie has got to be corroborative of their guilt.
Do you question the relevance or the whether it's appropriate for the judge to have found that some of the things the mother had done was indicative of wishing to cover things up? Is that a relevant conclusion?
Well, that is, I suggest, that gets us in those respects to the second point. They're significant lies about relevant issues. But was she covering things up for one reason or another? So, for instance, a fairly obvious matter that one would consider is that someone would lie through shame.
So you say the judge should have said, which is indicative of wishing to cover the things up, the things she wanted to cover up was her involvement in the bruising stroke fracture.
Yes, the only conclusion I can draw, or the conclusion I draw, is that she told that lie because she was covering up her perpetration of these injuries. But in doing that, she has to consider the full range, as Lucas invites, of all the reasons why people tell lies. So it can be a deliberate lie, it can be to lie about a significant issue, but it's what lies behind the lie that matters.
I mean, isn't the point of the Lucas direction to warn originally expressed, to warn juries against assuming guilt from a lie?
Yes.
That's the point. And to remind juries that people lie for all sorts of reasons.
Yes. But
And
they
it's going
can...
much further, isn't it, to say that before you can take a lie into account, you've got to be satisfied that the only reason for it is guilt.
Well, to take
Isn't that adopting the concrete approach to the evidence, which you've been criticising in another context earlier in the morning?
Well, I would suggest that the authority of this court is clear, not least from the judgment of Rie, and not least from paragraph 58 of Lady Justice McCur's decision, and in particular that a self-direction should not be formulaic. And she identifies how, if it is, and if it's incomplete,
The risk.
the risk.
Yes.
So, in my submission, paragraph 58 is good law, and that is why it's important, she says, that the lies need to be identified, and the reason for them identified in the judgment. So on what basis can it be determined that the only explanation for the lie is guilt? What matters in this case is that the judge doesn't descend into any detail. We say she gives a summary reference to Lucas. I appreciate she had a note of the law, but there's always a risk with a note of the law that the decision-making of the judge is lost unless the judge engages with the relevant piece of the law. Clearly relevant here for the learned judge to have said, these are the deliberate liars, these are the matters I take into account, coming to the conclusion that they point to guilt. Was the final point, but I'll deal with, I think, now, if I may.
Yes.
Relates to identity of the perpetrator. Now, it goes without saying that the judge's treatment of the bruising issue, in particular the 27th, the 28th, is problematic for the judgment. Had the judge engaged with the issue relating to bruising, first observed at 8 a.m. on the 28th, she would have been bound to have, had she addressed it properly, she would have been bound to have addressed it in this part of her judgment. But what she does do is she says, well, this is a mother who's lied throughout. She then says at 180, she spent the most time with the child. And that must be a relatively minor point. I mean, it doesn't take very long to injure a child. And really, I'm not sure that takes the matter any further. Both parties, if there was perpetration, had the opportunity. The mother may have had more opportunity, but that really, in the balance, against someone who might have inflicted injuries, is of little, if any, value when assessing which of them it was. She uses social media a great deal. It's hard to see that anything can be drawn from that.
Well, hold on. Your submission a while ago was the judge should have had regard to the social media messages. And she hadn't. Well,
She should have had regard to the fact that ordinarily in these cases one sees inferences that might be drawn from social media that could not be drawn in this case.
so how can you criticise her saying that she uses social media a lot, and if she suspected the father was trying to protect him, that might have emerged? Assume the evidence matters in analysis. Is what the analysis of the social media?
Yes, certainly of the photographs on the phone.
Right.
But I think also the media, yes.
Not an expression, I think. Is it a well-known evidence matters?
It is well known.
Is it?
The organisation.
Okay.
Yeah.
Oh, I see. It's the organisation.
It's called Evidence Matters.
I
yes.
see.
I see.
I understand.
It's
I
not-
thought she was
It's
talking
not a
generally.
new family court
Evidence matters.
buzzword.
Analysis. Yeah, exactly.
No, we haven't quite got there.
Anyway, she says here, so she does, you can't criticise her, can you, for taking into account, in this respect, the absence of evidence.
Well, I don't.
You do?
I can't see how this could be in any way relevant to the mother being a perpetrator. I mean,
But your submission previously was that the absence of any reference in the social media posts by the mother, which might suggest that she had inflicted injuries, was a relevant issue that the judge should have taken into account or addressed. Wasn't that your previous submission?
Yes.
Or did I misunderstand?
Yes. Because
Okay.
But here, she is.
So the premise of this observation of the judge is that she knew the injuries were inflicted,
Yes.
and had she thought it was the father, she would have said something.
Yes.
And the fact that she didn't say something in the social messages, text messages, indicates that she didn't think it was him.
Yes. And that's
Therefore, it
exactly
must have been
right.
her. But it doesn't. what about the option that she didn't know that it was?
Exactly. That's why I don't understand it. I mean, I can't. I understand my submission that I made earlier about social media, and I think my Lord understands.
Well, I put when I read this a question mark by it,
Yeah,
and I
I
still
don't
got the
understand
question
it.
mark there, as you have.
Yes.
I don't know what she meant by that.
So,
How
that's
does
my-
how do the last two sentences help us? He didn't suspect her. He simply believes everything she tells him.
of course, the real. I mean, the interesting point is that the judge goes on to talk about a loss of control, and what I suppose I should have addressed in the balance that I said the judge should have undertaken earlier when looking at the evidential pointers away from infliction, is there's no, apart from the child, I think she says, cried, there was no evidence of stressors. One is used to hearing about financial, housing, domestic abuse, drug-related, all sorts of pressures that prevail upon parents at a time their child is found to have inflicted injuries, and there's an absence of that. And what there is simply is I suggest, speculation as to a loss of control which caused these injuries. The point is that what precedes that, particularly in the paragraph 179 and 180, is insufficient to identify one parent over the other. As I said before, where she finds there is no failure to protect, what she is doing is using this evidence to point to guilt, and only guilt. And the matters at 179 and 180 do not permit her to do that.
Where does she make the point about being the dominant character?
Well, it's I suppose the end of 180 he simply believes everything she tells him. I think there may have been an earlier reference.
There was, but it's not. It doesn't appear in this passage.
No.
Is that part of her thinking?
It would appear to be, because there's that reference to he believes everything she tells
So
him.
that's
certainly what we assert.
So that is. I think it refers back to somewhere else.
Does, my lord, yes. Thank you. I think it's, yes, 157
Yes.
at 109. Thank you. My father signed the chronology.
Yes.
Okay. So that's a reference back,
Yes.
back to 157. So there are 5 factors, are there, that she takes into account. 1, the pattern of lying. 2, she was most of the time with Lucas. 3, she was on her own for long periods of time with a whingy baby. 4, used social media a great deal. And 5, dominant character. Is
Yes.
that it?
Yes. And those, in my submission, are being used by her, by the judge, to point to guilt. None of those in my submission, and certainly the line without the Lucas direction, permit her to do that. Ultimately, of course, if the father, and this is not the case that the mother hopes for, but if it were the case that the mother had, the judge had made the findings sought by the local authority in relation to the injury seen on the 28th, then this judge's judgment gives a clean bill of health to that parent.
Does she, before we come on to that, is paragraph 182 a 6th reason that she gives in some way? Or is it just discounting the point in the first sentence of 182? It was arguable she wouldn't have shown the photographs, taken all the photographs and shown professionals if she was guilty. And the argument is what she was trying to prove the baby bruised easily.
Well, I think if those or any part of that paragraph was used against her, she ought to have said so.
But I think what she's saying, it's not inconsistent with guilt, is what she's saying.
I think so. I think that's what she's saying.
So it's not a factor either way. But of course, part of your argument is that there was an important piece of the evidence of the events of what happened in hospital on the 28th.
Yes, Lord.
Or around the 28th of September, that should have been taken into account and was ignored.
Yes. And then, I suppose also in relation to the photographs, had she made the correct findings, and even on her finding that there was a propensity to bruise, what would you expect of a mother? I mean, on her finding that this child has an unspecified, unquantified, hard to understand, but still propensity to bruise, would one not expect the mother of her first child to photograph? I mean, how would that be indicative of guilt? It would recast the assessment of the mother. Should be seen as someone who was anxiously trying to get to grips with a real problem with no medical explanation. So I started with the bruising and I end with the bruising, and I say the bruising has a significant impact on the other submissions down the line.
What do you say should happen if we allow the appeal, first of all, on all grounds, and secondly, on the perpetrator ground? In other words, that the judge, if we say the judge was entitled to find the injury inflicted, but not that your client was the perpetrator.
My submission, there would have to be a rehearing in both cases, and I say that in relation to the second point, because of the significance of the bruising, which can't be detached from the identity of the perpetrator.
And if we allowed the appeal on just the perpetrator point,
Just on perpetrator.
would that mean a rehearing of the whole thing? Or maybe you want to think about it. Maybe you want to think about
I think the difficulty with you either have a rehearing or you don't.
Yes, that's right.
So I think there would have to be a rehearing. And because it would be for the judge to take into account all the matters that are relevant in respect of the mother and all the matters that are relevant in respect of the father. And there are, let me see, there are 4 potential outcomes that there's that the mother perpetrated injuries, assuming they're perpetrated, the father did it, that they both were responsible for injuries, or that there's a realistic possibility of either of them, so a pool finding. I'm not sure that this court could properly or fairly substitute a finding of either of those 4. May I assist yours?
No. Thank you very much. We'll start again at 2 o'clock.
My lord received from Mr. Alloway, I think at 11 o'clock, an electronic version of, of the unagreed supplemental bundle.
And you've now
3
got
paper copies came in, as my lord will have seen, about half an hour ago.
Can they, I don't think can they be put on the bench, and then you can take them to those parts that you want us to.
Thank you, my lord.
Thank you.